everyone. Thank you for coming. I am very happy to see so many familiar faces and a few people that I don't know, which is a good sign. It means that our call has gone out white, which is nice. I'm particularly excited because we have Kati Cseres, Associate Professor at University of Amsterdam in the Amsterdam Centre of European Law and Governance, right? And she is also co-director of the Good Lobby Profs,
yes.
which you might talk a little bit about, but basically they're defenders of the rule of law by holding EU institutions accountable. And she is a prolific researcher in competition law, and she has inspired Dave and I, because we were looking at how to hold competition authorities accountable in research, and then we heard Kati speak and we were like, we should probably do this better because she's raised the bar. So we are very happy that Kati is here to speak to us. So as usual, we will have a presentation by Kati and then we will open the floor for questions. But without further ado, I'm very excited you're here. Thank you.
Thank you very much, Magali. David and also Marco, thank you very much for the invitation and especially giving me a little bit of room to get out of the daily business that I do, which is not only teaching and research nowadays, but also heading half of a department. So it's really nice to be here. Thank you very much. Indeed, I'm going to talk about competition authorities, which might not be familiar to all of you, but I try to talk about things that should matter for all of us, whether you are a lawyer or not a lawyer, people on the street as well. The fancy title of my talk, which Politico picked it immediately, so they did an interview with me, so I thought maybe that sounds better than my second slide, is the competition authorities as quiet firefighters to protect democracy, but the real title of the paper on which this talk is based is Non-Majoritarian Regulators in Democratic Systems and the Case of Competition Authorities. Just to mention, this is a paper which is forthcoming already for quite some time, but hopefully it will arrive to the public in European papers. It is part of a special issue which some of my colleagues organized within a Horizon project which is called Red Spinel. Not about competition law, this is very much lawyers and political scientists working on how various institutions, for example, non-majoritarian institutions, should address ongoing dissensus on concerning liberal democracy. Okay, so that's a little bit what I need to say as the funding of this research. In this paper, I'm looking into, indeed, specifically, so if you read the paper, to competition authorities as independent regulatory authorities, independent decision makers, and I'm asking the question that how can they safeguard democratic institutions and the values of liberal democracy in basically this crazy world we are now living in. With all kinds of geopolitical, economic, social, environmental overlapping crises. But before I get into the nitty-gritty and the very specific part of the research, let me tell you a little bit where this whole idea comes from, looking at the role of competition authorities in our daily lives and more broadly. So I have been working over the past years on this intersection between democracy, the rule of law, and competition law, thinking a lot about what could be the role of competition law and what could be the role of competition authorities. These are some of the publications. I have been even flirting with the idea, but constitutional lawyers very quickly told me, quasi-courts, forget it. But still an interesting paper because we see that there is something special about competition authorities. And I have felt that already for a long time. There is some kind of glory around them. There is different from other independent regulators, especially if you meet or go to countries who relatively recently introduced competition law. I mostly look at Eastern Europe. For example, countries who are not yet part of the of the EU. Often competition authorities are the ones who get more funding or first funding, so there is some kind of prestige around these authorities, and I wanted to look a little bit better into it. So what is it that their role and function is, and asking the question of, indeed, do they play some kind of role that can bridge, that can be meaningful for democracy. Even more on the ground, the reason I have been looking at this, originally I come from Hungary. I lived in the Netherlands for a long time, and by now I have double nationality, which is not very popular, so I vote and worry about both countries. Some of my examples will be also from the Netherlands. But Hungary made me think a lot in the following way. Probably if you have heard about, in politics about Hungary, it's because it's backsliding from a democratic, relatively democratic, legal political system. But actually what has been happening in Hungary is also over the past 16 years an enormous concentration, accumulation of economic power. There are all kinds of very smart techniques, how public money becomes private money, how private money is used for public purposes, etc. But I think it's one of the most worrying issues today, and you may know, it may not, we will have elections beginning of April. Should there be, and there is a first chance now that there might be a political change, I think one of the crucial issues is, if the political system changes, what do we do with this enormous concentration of economic power? I put here also media. There is in that sector, but I could talk about energy, telecom, which are prime examples of this very high concentration. In media, there is 80% concentration in the hands of, well, this gentleman and his club. So businesses, sometimes personal, friends of Orban within a few hands. Against that background, I have always thought about, so what is the role of competition law in competition law and also competition authorities? The reason I put up media is because that's one of the most illustrative things, not just in Hungary, but also when I talk about the relationship between democracy and competition law, to explain also to people who may not be the biggest fans of competition law why it should matter to you, is because when media companies, firms want to merge, that's a question for a competition authority. In Hungary, we have seen quite a few. There is a very well-known, enormous concentration, a foundation in 2018, when almost 500 media outlets were put basically in one hand or a few hands through a foundation. And the competition authority should have looked at it because the competition rules partly address mergers or merger control. It should have been a question before the competition authority, also a question for the media authority, but nothing has happened. The government said this is of national strategic interest. There is not going to be a competition law review. I could give you some more cases. If you are interested, I can talk about it. The point for this talk is we have a relatively, on paper, independent competition authority. I often give the example, on paper, de jure, the Hungarian competition authority is more independent than the Dutch. If you work a little bit in competition law, then you know that the Dutch sort of progressive, effective, so it has a good reputation, a good authority. On paper, the Hungarians are more independent. That frustrated me. If there is an authority which also participates, by the way, not just in applying Hungarian rules, but also European law rules, because in certain situations, especially with regard to certain agreements, cartels, or abuse of a dominant position, they actually should be acting in lieu of the Commission. So also on the part of other enforcers, then we have a problem. if this competition authority is on paper independent, in practice, de facto, we see and documented that it's selectively enforcing the law. We also know, for example, cartels and mergers, that it's absolutely clearly under-enforcing. That's problematic. So why don't we talk about it? And why nobody talks about it? So that brought me closer to looking into, what kind of authorities are competition authorities? What do constitutional lawyers, constitutional theory or administrative lawyers say about that? How do they stand in the constitutional legal system of a country? Competition authorities are so-called independent regulatory authorities, like the energy regulator, telecom. They don't have a specific sector. They enforce the rules across various sectors. So it can be a case related to telecom or energy or agriculture, supermarkets, etc. But they have a much broader mandate. And they are so-called non-majoritarian institutions. That means that they have some form of public authority, public body, who oversee the protection of some form of public interest. That can be consumer protection, data protection, financial markets, etc., etc. I see something happened with that line, but it doesn't matter. So that's a definition of non-majoritarian institutions. Courts are also, so it's a broader category. Within non-majoritarian institutions, independent regulators are one of the, I think, 5 categories. What makes them non-majoritarian is that they are not directly elected, so they don't represent the majoritarian vote in a country. They are there. They have been created with the idea in the UK that, or in Scotland it may not be a surprise, because their legitimacy originates from they are the best in their work. They are the experts, they are the technical experts in competition law, they are the experts in financial regulation, telecom, energy, data protection, etc. But there is, from a democratic theory perspective, there is a deficit. So they operate without being directly elected and having that democratic legitimacy. Again, within that category, I was interested in competition authorities per se, and there we also see, so I was also interested what is the difference with, so what I see or feel that competition authorities are special, especially competition lawyers like to talk about that in a way, and heads of competition authorities even more. But indeed there is something special. One is what I have already mentioned, so they have a broad mandate, they operate across various sectors. They often have far-reaching enforcement powers, investigative powers. If you look at historically how it developed in the EU and the Commission itself, then compared to any other areas, it's the only area which the Commission directly enforces, and it can do quite a lot. It can go to the private homes with certain conditions of directors, CEOs of firms. So it can search quite a lot. It can impose fines. In some countries, they can send people to jail. So there seems to be, that's not what the telecom regulator would do. And my little hobby projects, they do have quasi-judicial powers. They sort of look at cases, case by case. Often a hearing takes place, so there is also adjudication. And why they are not courts, even though in some countries courts are involved in enforcing the competition rules, they do have different powers, and that will be relevant because that makes that their independence is even more crucial than any other independent regulatory authorities. So they require, because of this legal mandate, a high degree of independence. Before I move on, maybe a few other things. So one is about independence, and the other one about the mandate of competition authorities. I will pick this up in a moment even more. What is their role? What is their function? What do competition authorities do? They do today many things. I'm going to talk about democracy and the rule of law, but it's not, I think, immediately what you would think about, because their mandate is primarily looking at the economic dimension of the conduct of private undertakings in certain countries, and in EU law also of member states' conduct. But it's primarily economic effects. Their mandate is to safeguard, to make sure that markets remain competitive, to protect competition. Big debate, I will not go into that. Why I'm mentioning this is because I think what we see today is that this mandate is put under a lot of pressure. So to stick to that mandate, which is relatively narrowly defined, is becoming more and more difficult. More often there are cases that competition authorities, something that they try to push away, to take decisions which may have distributive effects on the market that may work out differently for different groups of users, consumers, workers, or citizens. Okay. I will come back to these technocratic silos in a moment. How to connect them to democracy? That's something I have been thinking and writing quite a lot, and I found it, I'm still fascinated by kind of a discussion, whether constitutional lawyers like it or not, or with how constitutional theory or constitutional lawyers also look at power. In a way, we do the same in competition law. We also look at power. We are worried about power. We are looking at the competition rules are to address, control, constrain, but sometimes also enable power. That's also a fact. But I have often seen competition law as a tool, and especially this is my thinking very much coming from Hungary, where you will hear and you read today, not just from competition lawyers, but often one of the things that you hear today is the lack of competition. The complete many major sectors and many sectors without any competitive market structure. So what they miss is also the enforcement of competition law, which can defend what has been also formulated as the market's equivalent of separation of powers. It really brings in the rule of law in economic activities, so how to, on the basis of competition rules, this is allowed, but it also sets a boundary to what is not allowed. And importantly for our discussion, it really, competition law and authorities have the role, and that's where my core thinking comes from, to defend our fundamental economic rights. And in Hungary we can see that. Maybe the media is again a good illustration of having an enormous concentration of economic power means that many consumers artificially pay, for example, for the energy prices. And the same things, or they keep prices, that's another issue what has been going on. They keep prices just around the elections, they kept prices as an economic populist measure, and then those prices go up after the elections, which again creates all kind of inequalities. So I see competition law as really as a guardian of democracy, and competition authorities who can have really a role to lock in market-based policies, and they can act basically as buffers against political will, and also dissensus as this has been part of our project. They also fulfill an important role when we talk about corruption. Again, Hungary is unfortunately a very important example. And of course, we constantly talk about, there are many examples, we address competition law and authorities that address market power, whether it's digital gatekeepers, media concentrations, or even state-owned companies. Those are, we know from research, both lawyers and economists, that this is a role which is crucial to counterbalance democratic erosion. Now, some constitutional lawyers and administrative scholars in public administration argued that even in autocracies, if you take Hungary as an autocracy, so a liberal political regime, non-majoritarian institutions, so competition authorities, can be can be the last pillars to defend democracy and push against such political regimes. Now that felt to me not okay. There was obviously an example where I saw that this doesn't work. So I was wondering what are the cases that we can talk about that. And I think it must be very specific strategies, very specific. And for me, the research was what is the institutional structures that can make these authorities, when the political regime and everything around them is falling apart, to say it in that way, that they can still defend these democratic values, the values of, let's say, liberal economic framework. And before I give you the clue to that, that's yes, a little bit going back to my metaphor of firefighters and what is going on today, and why I'm talking now about Hungary, but I think what we see also with regard to many authorities, many competition authorities today, is that it's not the pressure. What is taking part is not anymore sort of single cases, but there is a systematic pressure from these overlapping crises, whether it's economic, environmental, the health crisis, and actually I think over the past year we have even came to this simultaneous unraveling of the global economic order that I think many of us grew up with and believed in. I have been thinking about three specific pressures. One is really this concentrated economic power. Another one is time pressure. So I want to come back to that. And politicization, the risks of capture. And what I think we see, and again, so this is not just a case in Hungary, obviously it's an extreme case, but that competition authorities need to go beyond to this economic mandate. They need to do things that they thought it's not their responsibility. And to do that, they step into a sphere where they may have to make political judgments or engage in political, for them, political questions, which brings the risk of regulatory overreach, which brings the risk of politicization, and again raises questions about their legitimacy. I will try to be short about this, but this is an example, and I'm not going to with the digitals. Of course, we could talk about the digital markets, but this is a media merger case from the Netherlands, just to show you that it's not just Hungary, but also other countries. And an example also of the increasing concentration of economic power and how it puts competition authorities into a sort of an uncomfortable position. This is a merger which took for the Dutch Competition Authority, the Authority for Consumer and Markets, not to be mixed with the CMA in the UK, this is the ACM. It took them almost 1.5 years to come to a decision. I'm saying this because it will have relevance what I said about time pressure, etc. This is a big merger. This DPG Media is a Belgian media company with already substantial media outlets in the Netherlands, many newspapers, many magazines, many online news outlets that were already in their hands. Together with RTL, which also has news outlets, streaming, video, etc. Basically, almost the whole spectrum of the media landscape comes into one hand. There was almost no question that this would be a concentration of economic power. But what made it also difficult was, so obviously the Competition Authority must ask the question, is there restriction of competition? And what are the parameters of that? But what here, beyond the concentration of economic power and restriction of competition, and bad news for consumers because they will have probably less choice or less quality, there was also the very important pressure and question for the Competition Authority. Whatever we do, this will not only be, it's not like a fruit merger, which is also bad, I can see that. But this has direct and immediate impact on the media, on the news that we consume, on the political processes, on the public discourse, etc. So it was a super sensitive issue. Also, the chairman has said we just felt that this is not a case as any other, because not just the concentration of economic power was at hand, but what media lawyers often talk about, opinion power. So with this merger, you can influence what we are going to consume as news, what we will see, what we will read, and what we will listen to. And that made it a very difficult decision. They approved it. Whether that was a good decision or not, we will see. They approved it with a long list and very strict conditions, which all have to do with editorial independence, various sort of Chinese walls across the editorial boards, how the diversity of news should stay in place. What made this also very difficult, the Competition Authority had to step into a sphere which was not anymore just competition law and this economic dimension. So they had to say something about media pluralism, which is not their mandate. The Netherlands does not have a media pluralism test. I can talk about that as well. But the point for here is that, basically there was a journalist who wanted me in an interview to say they stepped over the mandate. I don't think so, but it was not clearly within the mandate to assess the reduction of media pluralism and say, well, this is an element of restricting competition. So this is a pressure that I see. I will go a little bit faster to get to the point. I also see, and I can relate back to this media merger, the time pressure. I see that many competition authorities, for example, with this media case, there have been 2 times a page, it's now in Dutch, so an advertisement by one of the biggest Dutch media owners, Van den Ende, who owns many media outlets, 2 times within that 1.5 years, saying that this should speed up, guys. What are you doing in The Hague? You are sort of, this is political slowness. it's obvious what the decision should be. So there was this urgency, and I think that urgency comes especially with regard to digital markets also. Do it faster. We are already late. Simplify procedures. We see that with many of the revisions of the EU competition rules and enforcement. Get rid of all those extra nice to have, like formal complaints, people who can, and organizations, civil society and consumer organizations who can also, ask a question, take even more time. We need to move on. We need to act earlier. We have to use ex-ante rules. We need to be more preventive, and in a way, once again, so this efficiency and urgency is, I think, very much put on competition authorities. And then, of course, the geopolitics. And something that, I watched the world over the past year like, it's exactly, I'm not joking, but I hear things from the United States that we have been very closely following in Hungary, things that I would have never thought that were possible, that kind of, I think there is a complete confusion also in the international competition community, that the ones who were always for collaboration on a global level are the ones who are pulling that back and saying, basically, our country first, our interests first, our economic security first. And that gives competition authorities also an enormous pressure of how to do it, what to do. I think the UK, I have been reading your and also some others writing, so this shouldn't be underestimated. But then I come back to the question, what is the solution? The solution so far was independence. I have heard it so many times, especially from, it actually made me really think from the chairman of the Dutch Competition Authority. I think several lectures that he has also given to the students, he said, you can ask me anything, I am super independent. And I thought, yes, but that raises a question. I am not sure. We cannot deny that independence is a very important cornerstone, both for competition authorities, but also for independent regulatory authorities. This is relates to what I think is the birthplace of why regulatory authorities should be independent in the US. This case from 1914, when the FTC, the Federal Trade Commission, one of the commissioners would be removed. Anyway, it's about the removal, which laid the stone down why independence is crucial and why the executive cannot, so political actors cannot intervene with that. This is one of the cases that we thought were set in stone, and we have seen that even that is not the case under the Trump administration. Nevertheless, and with that, we also know that if that goes, if that is taken away, then the founding, basically assumption, but also legitimacy of these organizations is taken away, because as I have said, they have been created to be independent at arm's length, to provide the technical expertise, because it was believed that this political neutral stand would produce better informed results. Now, independence is surely not absolute. So it's all competition authorities and all kind of regulatory authorities are part of a legal political system. You have to, as a competition authority, You cannot insulate yourself. You are responsible to the parliament. You need to talk to politicians. You need to talk to market actors. So it's always not full independence, but it's a certain degree of independence. Interestingly, a lot more scholars have written about what is independence and how we should understand it with regard to developing countries. And also this term embedded autonomy comes from one of the scholars writing about developing countries. So realizing when you have to introduce competition legislation, you have to put up an authority from one day to another in a maybe not fully democratic political system, it has to work with the rest. So once again, it will never be a full degree of independence. And what I think is also important to keep in mind, it's a political choice. We have to acknowledge that. So no, the Dutch competition, the chairman of the Dutch Competition Authority is not fully independent. He's part of a political choice. The kind of independence he gets is a choice of that country, what kind of economic policy they want to have, how much they want also the competition authority to do its own work. With regard to independence, one extra issue I have been looking into is also how the EU was pushing this as the glorious, most important issue with regard to the role of competition authority. And I have done, and I can speak about it, it's another paper which is unfinished, but I have done quite a lot of research about how the EU was passing on its legislation and institutional setup to, once again, those Central and Eastern European countries that joined in 2004 and 2007. And we see that for the EU, what mattered was a long time I believed, that was part of building democracy and market economies. And I had to come to the conclusion, reading a lot of political science, that actually it's yes and no. For the EU, what mattered is broadening, enlarging its markets, putting up a functioning competition law system with an authority meant that somebody is going to administer what is happening in those markets, and that investors can move in, trade, investment, economic activities across the border will be safeguarded. For that, they have been pushing a certain very, very neoliberal model, also because that was the time of that. And we also see later on, this is quite later on because we are talking about 2019, that independence remains also the primary dimension for competition authorities. So that's what we see overall in the documents, also in this legislation for making competition authorities more effective. There is a whole article or part of an article about independence. There's nothing about accountability. Because what matters is independence is also related to, more related to efficiency, expertise, doing what you as a technical expert find important, and again, don't slow down because consumers want to ask a question and then you have to answer it and you lose time, and again, your decision will come later. So I think we can also see that the EU, through its Europeanization, through many also soft law documents and all kind of discussions where, in a way, voluntary harmonization was going on, I think it was pushing very much also this independence. Is that bad? To some extent, I didn't talk about it. I think independence has a side that is almost not to be talked about up until now, which is that it also creates distance between the authority and the rest of the society. And that has been very much in competition law due to the fact, because independence also went hand in hand with the adoption of a more economic approach, with making the language of competition law decisions, scholarship much more technical, so this technical expertise, and creating, I don't know if any of you have studied competition law and ever tried to explain to your grandmother, parents, what it is about. Ever tried that? I had a French teacher a long time ago in Amsterdam, and I think she was very much that socialist French side. She just could, she said, no, I don't understand, this is a lot of money. And since then I know we need, and I think that's also for competition authorities, a big question of how do you translate that kind of work that you do, where this insulated technocratic community of mainly lawyers and economists, and now maybe data scientists and computer scientists sit, what does it mean actually on the ground? What does it mean when you go to the shop, when you have to go to the hospital? Now with the digital markets, maybe it's easier. But there has been a sort of insulation of these authorities to broader society, and that I would translate also losing some of their democratic legitimacy. So some people talk about them as technocratic silos who operate. We often also hear people saying, yes, but competition law is different. Why? Or what is so special about it? So in the whole narrative, I think something created that, yeah, it's put on in a different box. I don't know. So the question is, can we talk about accountability? Can we actually discuss this issue of that there is a deficit on accountability? Once again, I think that the EU framework has been very strong on independence, be more efficient. But at the same time, and these are my last slides, there are, of course, accountability mechanisms, especially on national level. Competition authorities have to go and report to the national parliament. They write annual reports, luckily, because we also learn a lot about their work. Their decision is subject to judicial review by the courts. There can be various ways to interact also with the broader public, and of course they are subject also to financial audits, so court of auditors, etc. in a country. Now this can have a big variety across the countries. I'm not saying that bad, but we have to realize that there is a big diversity of what kind of mechanisms apply. And some scholars also argue that some of these mechanisms are weak. So to the parliament, it can function as a kind of fire alarm mechanism. The courts will never go into political questions. We are never going into the distributive questions. They will only look at legality, correct procedure, and that's their mandate and their remit. I personally don't believe in the peer review anymore. I think I don't believe in it anymore. I think there was a period that we could believe in it. I don't. After Hungary, I don't believe in it. I don't think it exists. I think it exists with maybe developing countries. I think it's not a level playing field who can review whom and say what. It can take place within the European network of competition authorities. ICN, I don't know if they do it, the OECD does. So, but that is also a crucial mechanism. And then accountability can also be exercised through formal complaints. And I have worked quite a lot on formal complaints. I see them as an important watchdog, a control on what the administrative authority, the competition authority does. It functions a little bit as a court, because they ask questions, they contest certain facts or information that the competition authority has collected. They question the direction of the decision being taken. So I find it an important one. It's a different type of accountability than a court. It brings in different interests. It's also different from national parliaments. We also know, so I don't want to be here the one who doesn't acknowledge that this can be also abused, formal complaints, we know that. But we also know that, and that's my research and I stand behind that, that it's very narrowly defined. In the EU, I am very confident to say that the Commission has pushed very much, that the countries also narrowly define it. So to be recognized as a complainant is not an easy task. In the Netherlands, it hardly ever occurs. To show that you as a consumer has been directly impacted and you can actually stand as a complainant. There are also very, very different participation rights. So can you write a letter, an opinion? Can you be heard at a hearing? Can you express your interests? Is very different. Some countries allow quite a lot, others not. But I think there is a tendency to cut this off. We see it with the Commission. The DMA does not have any formal complaint position. These NGOs always say, yeah, but we talk to the Commission. And of course, but if there is a decision or a step they take, you formally don't have a standing and you can't do anything. Some other legislation, we also see the revision of Regulation 1/2003 is being cut back. So we see a tendency of cut it off, make it faster, make it more efficient, and get rid of formal complaints. And lastly, some competition authorities hold public stakeholder consultations. But we should be critical with those as well. It's often those who are well organized, who have enough financial resources, they can stand up, they can present the interest, they can go to all, DMA workshops, etc., etc. So that may not function in an ideal way either. And this is my last slide. This is the most important part, so thank you for being so patient. So what can we do? How can and accountability is a dangerous topic, I think, because what we see nowadays also going on either in the US or on national level, the EU is in the direction of politicization. So I'm not arguing for that. I do see the risk of keeping more competition authorities more to account can indeed go into the place of politicization. At the same time, I think also in the UK there are voices of, yes, but we have to enter that forbidden room or forbidden space. And then I think we can think about accountability mechanisms, some of those that I have also talked about, in a way that it will not slow down or not so much slow down the procedure. That it can also select and make sure that the ones who are standing up as a civil society organization or a consumer organization is not some kind of corporate lobby financing the so-called organization. I use for that two strands of scholarship. One is responsive regulation, not the main ideas, but the so-called tripartism, which also talks about and says that how the participation of third parties, so in competition law is the enforcer, and the undertakings under investigation, those are the main parties, and the third parties could be consumers, could be other firms, how they can be brought into the decision-making procedure. And the other scholarship comes from so-called social accountability, so how to bring back more reintroduce citizen and stakeholder voice to participation, deliberation in a collaborative manner. And again, these also have risks. So ad hoc both the CMA and I think the ACM, the media merger, one of the reasons that it has taken so long is that they have organized a lot of meetings. There has been a lot of meetings with the media regulator, with players in the media market, with consumer organizations, civil society organizations, academics, academic opinion. So one reason was that they have maybe over-consulted, I don't know. Interestingly, one of the cases I picked out from the CMA, Stuart has told me, is also a media merger case. So there must be something about media where there was also a public or stakeholder consultation. But we see that, when these authorities want to have that, it's a sensitive case, they will organize that. But it's not something which belongs in an institutionalized way to the functioning of these authorities. So I think it would be there was something called the consumer panel. I asked Or to look it up what it was and why it disappeared. So some kind of institutionalized, and I think there was also citizen panels in other regulators. So some kind of panel in the UK with regulators who would give an opinion, who would function as this accountability mechanism. And another way, what I still need to work more, and I think there's very little about, is how to make these formal complaints more, thinking along the lines of super complaints, when it's not each and every case, not each and every member of society, but some kind of privileged, some kind of threshold that we know that those who use that mechanism are really representing a broader societal interest or stakeholders, not in each and every case with certain thresholds and frameworks and deadlines, because being aware also of the fact that decisions have to be made and also the work has to be finished at a certain point. So thank you very much for your patience, and that was my talk.